Hi, I'm Kurt Harris with the Men's Family Court column. Today I want to talk to you a little bit about specifically divorce. Grounds for divorce are set forth by statute or code, depending upon your jurisdiction. In the state of Nevada, there are 3 grounds for divorce. In other states, there are a multitude at times. I've seen some states where there's 9 grounds for divorce. It depends upon what you're looking at or what state you happen to be in or what the jurisdiction is. But it's specifically in Nevada, we have 3 grounds, which seems to make the most sense. Those 3 grounds are insanity, separate and apart for 1 year, and irreconcilable differences. Generally and almost always, irreconcilable differences are the grounds that should be used in almost every divorce case. The first ground that we have is insanity, as I addressed, and it's almost insane to try and plead that because you have to show the other party is essentially not in their right mind at all, and that requires medical documentation when the grounds of irreconcilable differences is available to you just out of a difference of opinion. Secondly, the separate and apart for 1 year essentially requires that you establish that you don't know where your spouse is and you haven't seen him for a year. That can be pretty persuasive at times, but it's generally not very frequently that we have that. Almost always my clients know where the other party is or have a reason to believe they know where they're at and be able to find them relatively easy. And if you don't like the fact your spouse has been away for more than a year, that's certainly an irreconcilable difference, which leads us to the catch-all of irreconcilable differences. That is what should almost always be used in every divorce case as a grounds for divorce. And that is pretty much all that I am willing to utilize for my clients because it is the quickest, easiest way to establish grounds. And essentially all that happens to be, and we have a very famous case here in Nevada where there were 2 parties that were getting divorced and the husband testified that he did not love the wife anymore and the wife testified she loved the husband. The judge granted the divorce because they could not agree on whether or not the other party loved the other party. That was enough in the state of Nevada to obtain a divorce. In the state of Utah, they have a lot of grounds. One in particular, which I find particularly distasteful, is the grounds of adultery. Why don't I like the adultery? Well, although it may be a particular ground for divorce, it certainly would be an irreconcilable difference here in the state of Nevada. If you disagree, then that's enough. And the problem with many of the cases in Utah is that they plow into many of the personal, bedroom type testimony that none of us really want to hear. And most of us would really like to get on with life and not discuss that. In the Nevada courts, proof of adultery or of another party cheating is irrelevant in court and cannot be brought up, and judges generally will not ever entertain it without some other very, very important supporting reason why you should hear that. So for the most part, the information and the antics regarding what goes on with people's personal lives when it doesn't involve children or the other party is irrelevant in court. And that's why we appreciate here just having the grounds of irreconcilable differences, because that encompasses all without having to go into all those personal items, which can drag down a case and which can go on for days as to who's at fault or who did what to who and when. And it involves third parties over which the court doesn't have jurisdiction and over which it really doesn't matter. So in Nevada, we use irreconcilable differences as in most jurisdictions, and that is really the best way to go when contemplating a divorce and which grounds you should proceed upon. Once again, this is Kurt Harris with the Men's Family Court column. I look forward to talking to you in the future on other topics. Thank you.